what time it is. Buckle up and enjoy the ride.
And we are live. Greetings to our loyal WFYL listeners around the world. Welcome back to your Philadelphia live stream, only on the Freedom Station. I want to thank each and every one of you for tuning in once again, because you still have the right to hear and the right to be heard. Ladies and gentlemen, my name is Mike G. As always, with me are Philly Chris, Russ the producer, and Liberty Lee. And you're listening to Mike G in the morning with The Law Matters. And you can listen to our program every Friday at 7 a.m. Eastern, only on the Freedom Station, WFYL. So let's be heard. I want to remind our listeners that you can participate in the free and open exchange of thoughts and ideas throughout the entire week by visiting MikeGinthemorning.com. What's it called, Philly Chris?
MikeGinthemorning.com.
How about you, Liberty?
MikeGinthemorning.com.
Special guest Rick Vasquez, what's it called?
MikeGinthemorning.com.
And my right-hand man, partner in crime, Gilbert Ambler, what is it called?
MikeGinthemorning.com.
So tell your friends, tell your family, tell your barber, tell your Uncle Jerry, tell anybody who listen to check us out at MikeGinthemorning.com. I also want to remind our listeners about the powerhouse lineup we've got here at the Freedom Station. Kick off your mornings with Scott Adams, bringing you the Scott Adams Show weekdays from 9 a.m. until 11. We've got the one and only Dan the Man Bongino, bringing you the Dan Bongino Show weekdays from noon until 3 p.m. We've got the headliner, intellectual giant Ben Shapiro, bringing you the Ben Shapiro Show weekdays from 3 to 5 p.m. And finally, you don't want to miss it. We love having him at the Freedom Station family. We've got Michael Knowles, bringing you the Michael Knowles Show weekdays from 5 to 6 p.m. So don't forget to tune in and show him some love. And with that, you know what time it is. Buckle up and enjoy the ride. Hit it, Russ.
You know what time it is. Buckle up and enjoy the ride.
We've got a lot to talk about today. We want to know how many of us law-abiding gun owners out there turned into felons overnight, going to jail for a very, very long time. This is the way it rolls. So to jump in on the topic, we've got two of my very learned and esteemed colleagues. We've got Rick Vasquez, and for those of you who didn't see him on our program last time, Rick has got a wealth of experience. He had a 21-year career in the Marine Corps and ultimately served with the ATF in the Firearms Technology Branch as a firearms enforcement officer. And Rick is responsible for a whole lot during his tenure. And he serves as an expert witness, serves as a consultant. The man does it all. Rick, thank you for joining us.
It is definitely my pleasure.
And also, we've got my esteemed colleague, Gilbert Ambler, the owner and founder of Ambler Law Offices with practices in Virginia and Pennsylvania. He is my co-program attorney in Pennsylvania for U.S. Law Shield. Been working with him for quite some time. And the man's done it all. You look at the Virginia newsletter that was circulated recently. I had somebody send it over to me and say, hey, this guy's got some comments on the whole pistol brace thing. Have you ever heard of this guy? I said, and as a matter of fact, I have, Gilbert. Gilbert, thank you for joining us.
Happy to be here.
So, Rick, first of all, I want to jump to you. I understand that you're out at SHOT Show now.
I am. It's a pretty good event, but it is definitely tiring.
There's a whole lot of displays going on.
Oh my goodness, the floor space is miles. And plus I have a booth set up and talking to people on a daily basis. I can barely speak, losing my voice.
Oh, well, I'm glad you saved just enough to join us this evening. What kind of stuff do you do when you're over there? Do you have people who are coming on over and talking to you about consulting services?
Well, I do a lot of different things. I work with a lot of importers and manufacturers, and I also market a couple of different products, Tech 10 Tactical Rifle Slings. I'm a business partner in that organization. But correct, these people come over, they know I'm going to be at a certain place, and we discuss all of the issues that are ongoing, how it can benefit their business, how it can keep them out of trouble. Unfortunately, you hate to say that, but that's something that you have to work with in the firearms industry. You can just do your business on a daily basis, be happy, and all of a sudden you're in trouble, like possessing an arm brace, and you have no idea how you got in trouble.
It is a cost of doing business. Do you find that even people who are in the businesses that what they do for a living, when they come over to you, they have some misunderstandings about what they're supposed to do and what can and cannot get them into trouble? Because I've seen tons of pictures on the internet in this past week alone where you have folks who own major operations who seem to not understand what's going on here with this recent rule. Do you find that there's a lot of misunderstandings out there?
I don't want to call it a misunderstanding. I want to call it an misinterpretation.
Mm,
So, ATF is responsible for interpreting the regulations that run the firearms business, and you can have an interpretation that changes overnight.
right.
A good example is ask 20 different gun manufacturers what the definition of manufacturing is, and all 20 of them will probably be wrong because ATF takes that manufacturing statute and changes it from time to time. And unfortunately, let's say Gilbert wrote in a letter and said, "Hey, I want to know if I'm putting a finish on a firearm, is that considered manufacturing?" Well, he gets a response. And so Gilbert knows what he's supposed to do, but the other 999,000 people don't get that response. So when they
Mm,
come in and somebody looks at what they're doing, they're in violation of the manufacturing regulations. Same with the acquisition and disposition law. Same with many different items. And Gilbert and I have worked together before on several of these occasions. And then you go into a company and you sit down with them and explain everything that they're doing. I don't want to say wrong, they're doing it incorrectly because they read the regulations. They received basically maybe an hour and a half or 3 hour introduction when they got their license from somebody it took 20 years to learn their trade, but then they get this 1.5 hour introduction and they're supposed to understand the trade. So all of a sudden they've been doing the same thing for 10, 15 years and their license can be revoked.
right. Right. And they finish up with those meetings like, you got all that, right? You've got all that. You're good to go. Gilbert and I have said in those. Now, Gilbert, I want to ask you, I want to bounce over to you. What has the last week been like? Because you and Oliver were on the program last week. We were just talking about pistol braces. We even speculated that it was possible that because of the bump stock thing, which Rick ties into as well, because of the bump stock decision and the circuit split, that maybe ATF was going to hold off on sending this down. And wouldn't you know, their ears must have been ringing because the following day this thing drops. It turns out that we were wrong. Is that fair to say, Gil? We were wrong.
That's fair to say. And, I would love to be a fly on the wall at the ATF's booth at SHOP because I'm sure they are taking so much heat for this right now. I would love to hear what people are saying to them. But it's a big one, obviously, because it affects so many people. You've got, Congressional Research Center saying maybe up to 40 million of these things in existence. And so that's an awful lot of folks that are potentially affected by this rule.
Is your phone ringing off the hook?
Off the hook, nonstop. So emails coming in, phone ringing. If every week was like this, I would need to hire 10 more of me just to stay on top of it all.
Hopefully, for their sake, they're U.S. Law Shield members because those are expensive phone calls if you're not a U.S. Law Shield member to ask those plain old questions. Do anybody bring back to you, hey, this is what I heard, and it's something completely off the wall?
There's some misinterpretation, misunderstanding, call it what you will. What I'm seeing more than anything else is people seizing on just a very, very small part of the rule. For example, they picked up from somewhere that there was a length of pull analysis, and they've decided or heard or been told that so long as their firearm is under the length of pull requirements the ATF is looking at. For example, it's a 10-inch length of pull. They're thinking they're going to be okay. And as we all know, that's not how the rule is set up. There's no single determinative issue such as length of pull that, 10-inch length of pull. Well, in that case, it's just a brace and you're good. It is not written in that fashion.
Right. And Rick did an excellent write up on this quite a while ago. I don't know that it necessarily clarified it because I don't know that it's capable of being clarified. But I think what we ought to do, because I don't know that everybody who's listening right now is completely familiar with what's going on. So I want to sort of start with the top and then dig into this because we've got a lot to unpack during this episode. And I want perspectives from each of you. Gilbert, in particular, I know that you've come out with a position as to how individuals should potentially handle this. And Rick, obviously, you're going to know the ins and outs of all this stuff. You've written literature on this kind of thing, and this is what you did for a long time. But I think we could start with the basic premise that short-barreled rifles, barrel length under 16 inches, overall length less than 26 inches, are regulated under the National Firearms Act, right? So we start with that basic premise, and that the ATF let everybody know that quite some time ago. I mean, this was probably back in 2013, was it? 2013?
2012 was approved.
12 was the first one that was approved. So the stabilizing brace, and it's a brace that goes on the end of an AR pistol, right? Because when you're looking at the definition of rifle, what's included in that definition?
Designed to be fired from the shoulder.
Right. And so these pistols are not designed to be fired from the shoulder. And so if you attach this pistol brace, it's supposed to functionally assist someone at shooting this thing one-handed. Is that fair to say?
That is absolutely correct.
Okay. So ATF comes out and says this is not a rifle and therefore not an SBR. It's not regulated on the NFA. It's not an NFA item. Then over the years, people kept asking different questions, started modifying these braces and submitting different designs. They flip-flopped back and forth to agree. At one point, they said that if you put it up to the shoulder, then it is an SBR, or you've effectively redesigned it, which makes no sense because when you hand it back, what happens? Now you've already, you hand it to somebody else, you've already redesigned it. But for the most part, the understanding was that this is not an NFA item, and this is simply a brace attached to a pistol. Is that a fair sort of real cursory analysis for everybody who's listening?
Good 1,000-foot overview.
Okay. And now, if it is regulated under the NFA, if it is a short-barreled rifle, then you'd have to go through a process where you register with the federal government and pay a tax. And we spoke about the NFA on the show last week. And if you don't do that and you have an NFA item, then you're committing a felony and you go to jail for 10 years. Correct on that?
Well, it's the maximum.
Absolutely.
Maximum.
Yes. I mean, they could tell you take the offending feature off, but if they're playing hardball like this administration is doing, then they would probably try to prosecute or get you to plead guilty just to a felony, and because no one can afford to fight the government.
Those cases do get very, very expensive. You've got a federal case, you better have 6 figures laying around somewhere because they've got unlimited resources, and it's a whole different ballgame when you get into federal court. But this rule that came down, what they're saying is that these are NFA items. They always have been, even though we explicitly said that they were not. Do you agree with that, Rick?
Yes, that's exactly what they're saying.
Gilbert, do you agree with that?
I do.
Okay. Creates a whole host of problems. So, Rick, why don't you outline a little bit about their reasoning? Because I know you wrote about this extensively. I've read your publication on this multiple times. And then what they're claiming that you can do in order to become compliant, because you're already in possession of something. So you've already committed the felony, according to what they're saying. That because it is and always has been an NFA item, you're a felon. You already have committed the felony. But because you're being super nice, you got 120 days, we're going to allow you to do X, Y, or Z. So, Rick, I'll ask you to take this one away.
Let me go a little bit on this historically, though, so that
Sure.
it's easier to understand. Prior to this arm brace being approved, there was multiple people that wrote in on, if not a monthly, a biannual basis, different people wrote in and tried to get arm braces approved, and they were never approved. very consistent. ATF felt that somebody would be using them as a stock. So in 2012, SB Tactical had one approved on behalf of a disabled veteran, and it was approved. And in that letter, this is very important. They didn't say it must be black in color. It must have this much space in the rear. It can only fit around a little pencil arm person's arm, and it can't be longer than 10 inches. It was just an approved arm brace. And there was multiple letters like that. Well, once ATF decided that they didn't like what they had done, a couple of people wrote in. One person wrote in without mentioning names or positions and said, if I put this under my shoulder, am I creating a short barrel rifle? And ATF responded, yes. Then another person wrote in and said, if I shoulder this device, will I be creating a short barrel rifle? And the answer was no. And then it went up to the assistant director, Marvin Richardson. And on behalf of Marvin Richardson, ATF chief counsel, now this is their chief attorneys, put the letter together, the infamous Marvin Richardson letter, that said basically putting it against your shoulder does not redesign that as a stock. It doesn't agree that you can shoot with it, but it tells people it's not redesigned as a stock, so it's not a short barrel rifle. In the meantime, they start coming up with these length of pulls, and they took the length of pull from the NRA guidebook. Now, here's ATF writing what they considered law in a letter from the NRA guidebook. You know, the little guidebook that tells you what's a stock, what's a scope, and that's where this length of pull came from. And they put it directly into their letters and their reports. So length of pull became a factor. Then the size of the opening became a factor. Then the way you attach it became a factor. So it got to the point that ATF had just really gone down the rabbit trail, and then they decided to write a regulation to put something in a regulation that had more power than a law. And then it came, and basically they started out with the 49.99 sheet, which I thought that would go away because it was so incomprehensible, nobody could understand it. And so that went away. But in the new ruling, it's so subjective. So basically, if me and Gilbert were sitting at two different desks, I may look at something and say, this is not an arm brace. Gilbert may look at it and say, this is an arm brace. So the person I'm writing for may get an approval, and the person Gilbert's writing for may not get an approval. So that's where we're at today. And no arm braces are approved right now because even the ones that had previous approval have now become null and void. So as you said before, so when you look at it lawfully, I hate to use the term legal because I'm not an attorney, that anybody who has one is now in possession of an unregistered short barrel rifle because ATF just said none of these are approved as a short barrel rifle. So that's kind of analysis of very, very cut and dry of where we're at with this ruling without going really in depth on the different points.
Gilbert, do you want to jump in here and talk a little bit about this? Because it's pretty scary that you've got this agency that can come in here and essentially rewrite the law. I understand that they're responsible for enforcement and they've got to go by something, but it's scary that the folks who are responsible for trying to lock people up are saying at one point, this is perfectly fine. Yes, we promise you're doing the right thing. And then we changed our minds, but we pinky swear that we're not going to prosecute you if you do exactly what we say in the next 120 days. And we know that we already told you that this was legal. And now we changed our minds and said that you've got an unregistered NFA item, which is a very, very big deal. But we pinky swear we won't change our mind about the 120-day thing. What do you think about this, Gilbert?
Well, and they've given people that find themselves in possession of one of these items essentially 4 possibilities, and I don't think any of them are great. Possibility number 1 is turn your weapon over to the ATF, which I can't imagine any law-abiding gun owner saying, "Yep, that's the one for me. I'm gonna go down to my local field office and hand over my AR pistol." I think that's a terrible option. Option number 2 is conform the weapon as a rifle, essentially purchase a barrel longer than 16 inches, install barrel barrel longer than 16 inches. Make sure the overall length is over 26 inches. Voila, you have a rifle. One tiny issue with that is there is no official, essentially, statement out there saying that they will not prosecute you for your previous possession of an unregistered short barreled rifle. Because if you did have it in a braced format, there's possibly an issue still should somebody really decide to come after you. There's not been an official grant of immunity for your possession of that. If somebody really wanted to jam you up, and I tell people all the time, is this likely? No, it's not likely. But as an attorney, my job and your job, Mike, is to worry about what's the worst case scenario. What's the worst thing that could happen? And that is a possibility. A third thing you could do is get rid of the brace and destroy the brace and leave the weapon as a pistol. Again, although it might be left as a pistol, still the possibility that somebody comes back within that statute of limitations and decides they're going to prosecute you for the prior possession of the short barrel rifle. And then option number 4, which I think is the most complex option, is you can go ahead and submit a Form 1, which is an application to make a short barrel rifle. And of course, this is where things start to get really wonky because your item is already made. It's already assembled as such. Right. They're saying, that's okay. We're just going to ignore that inconvenient fact. Go ahead, apply on a Form 1. And,
we'll even waive the tax. We'll even waive the tax, Gilbert.
Even waive the tax. As long as you make it convenient for us and electronically file it, we're happy to do that.
Very thoughtful.
Go ahead, file the Form 1, and no one's going to bother you as long as you can show that you filed this application.
Interesting how they created the NFA as a taxing scheme because Congress thought there was no way they had the authority to regulate firearms otherwise. And now they're choosing to enforce this in a manner that involves no tax whatsoever. I don't know if there's something there, Gilbert, but we might have to discuss that.
I mean, I think we should at some point definitely talk about possible things that will be litigated with this, because I've got a whole list of things that I think are sort of ready to challenge this rule with.
Because you've got the basic common sense, anybody with the intelligence that God gave geese route, right? And then you've got a Second Amendment route, but you've also got a powers of Congress, specifically enumerated powers route. If this is a tax law, which they're trying to enforce their end goal without the tax part.
Right.
So do they have the authority to regulate by not taxing? Interesting. I'm not a tax lawyer.
There's a lot of very interesting questions. One of the things that we've been talking about is the Fifth Amendment, right? Because you're essentially, when you submit this application, an e-form, you're saying, yes, this item is an SBR and I want to register it as such. I recognize that your standards apply to my weapon, and therefore I want to register it. And in doing so, you're making some admissions. You're sending them your fingerprints, your photographs, you're sending them pictures of your weapon. And when you do this, I think you've got an important Fifth Amendment issue. The Fifth Amendment is something that the Supreme Court has previously looked at in the context of NFA items. They looked at it in a case back in 1968 called the Haynes case. And in that case, at issue was a crime for failure to register. And in response to the Haynes case, Congress passed 26 USC, I believe it's 5848, which says that information prior to applying for a tax stamp and simultaneous with the application for a tax stamp can't be used against you in a prosecution. And that makes sense because traditionally when you're applying for a tax stamp, you are not yet in possession of an illegal item. However, that prohibition on prosecution, which is up till the filing of the tax stamp, as long as you're trying to get the tax stamp, is somewhat flipped on its head here because you are already in possession of this thing. And they're saying, don't worry about it. You can hang on to it while you wait for that tax stamp to come back. And so to me, it raises a couple of important questions. Number one, what about that time period after you file the application? Because I think there's a Fifth Amendment issue there. I also think there's a Fifth Amendment issue. What happens if you submit your application and you get disapproved? They don't approve it, and you've sent them your fingerprints, your address, your photographs, and admitted that you're in possession of this weapon. So I think there's some interesting Fifth Amendment issues that will have to be litigated on this.
Do either of you want to talk about the whole return without action thing? Because that's real. We see that happen wrongfully frequently enough that it's on our radar. Rick, do you want to touch that, or do you want Gilbert to take that?
I'll let Gilbert take that. I think he's more versed on that issue than I am.
Sure. Well, and there's ongoing litigation on this point as well. And what happens with ongoing litigation is every time somebody seems to have a good challenge, they moot it. If you challenge them with somebody who is actually prohibited and shouldn't possess firearms, well, then that would be a bad challenge for you because you're going to lose. You're not going to win either way.
Right.
If you challenge them on somebody who is actually eligible, but they denied, then they're going ahead and they're approving it and saying, aha, it's moot now. You can't continue the challenge. And of course, most people don't want to continue the challenge because lawyers are expensive. But this is a long-winded explanation for what you're asking about, which is the fact that when someone applies for an NFA item for approval via a tax stamp, the ATF is, if it's delayed, because the ATF is running the NICS check, and if it's delayed for too long, the ATF is either, and they're not necessarily denying, they're returning without action. So there's shooting it back to you, and there's no viable appeals avenue. They have not been processing appeals, and this is what the litigation surrounds, is whether this is permissible with our due process standards for the ATF to be doing this.
So, Rick, I want to jump back to you. Is there anything that you have to add about the options that they've given us in this ruling? If for anybody, and when I say us, I'm talking about any of us law-abiding gun owners who may potentially own AR pistols with a brace?
There's a facet of this that I think people should be very self-conscious of, and that's being in possession of an unregistered short barrel rifle, and the possibility you're going to have a lot of denies. And I say that because the quantity is going to overwhelm the system. We're estimating, ATF estimated over 4 million, CRS estimated over 40 million. It's easily over 15 million without even second guessing anybody. So they can't handle the influx of paperwork today. So as this starts progressing, their old systems are not going to handle it, and they don't have the personnel to handle it. So any bump in the system, it's going to get denied or sent back for more action. So now you're really going to be in possession of an unregistered short barrel rifle. Now, I highly recommend people to separate it and put it somewhere else. Now, in this, they had a town hall here, and one of the questions asked was about the Thompson ruling, where if you possessed a firearm that could be made into an NFA or a non-NFA, it was not going to be an NFA firearm. And so they asked the question about, how are you telling us that we have to destroy it when if we separate it from the firearm, we're no longer in possession of a short barrel rifle? So they kind of just hem-hawed around that, because if I take it off and take it to somebody else, I'm no longer in possession of control. I don't care if it's still my property. I don't have to destroy my property. When you look at prohibited people who are married, the wife can still have a firearm in her house if under lock or key. I mean, and that's been written and fought many times. So how are you going to tell me that if I possess a stock, I can't take it somewhere else and secure it until my paperwork comes back approved? So there's going to be a lot of issues that pop up with this, and there's going to be guinea pigs, because out of the 40 million, how many applications are going to be made? Let's say there's only 10 million applications made, just a small number. That's going to overwhelm the system. So there's going to be there's going to be an officer come knock on somebody's door and ask him if take that shoulder stock, which used to be an arm brace, away from him.
I don't consent to any searches, and I will not make any statements without an attorney. Thank you very much. No matter what.
I heard they're going to cross-train the IRS agents, the 87,000 IRS agents, to help with that.
Well, it is a tax law. It is a tax law, as we discussed. It's an interesting point that you brought up about constructive possession, Rick, because when you're talking about a husband and wife, you got one who's a person not to possess. You have actual possession where you're holding something in your hand, and then you've got constructive possession where you have the ability plus the intent to control something. So if you've got the wife who is not prohibited and the husband who's prohibited, and she owns her own firearms that are in a safe where he doesn't have the combination or the key, he is not possessing it because he does not have the ability to control it. Now, there's another fine legal argument because it's the ability plus the intent where somebody has access, but they have no intent to control it. And those are always jury trials. I can tell you that from experience. Those are always jury trials because it becomes an argument over whether there was intent. And you don't want to be at the jury trial making the argument.
And I think it's worth, sorry, I don't mean to cut you off, Mike, but I think it's worth highlighting because Rick referenced the Thompson Center case. And one of the important distinctions there is you take the brace off and you have the ability to put it on another firearm. For example, if you had a rifle sitting there that had no stock on it, that was just waiting for a brace or a stock that would still be an over 26 inches overall length, that's sort of a much more similar fact pattern to Thompson Center. Whereas you take the brace off, you have it lying around. Now Rick had talked about removing it from your control, but you take it off and you leave it, in the same safe as your pistol that it used to be affixed to, and there's nothing else that it can go on to. That's going to be a different fact pattern where the ATF would likely argue constructive possession. So it's important to understand. In fact, Rick and I taught a CLE down in New Orleans this year where I think some of the attorneys there might have misunderstood this distinction on whether it can fit together in a lawful pattern or whether the only way it can go back together is in an unlawful pattern.
And we talked about all the stuff, the information is coming out there. I think this is kind of a good point to put out there. I've seen a lot of information on the internet that's absolutely incorrect, and I believe in the Second Amendment, but sometimes when you tell people, I don't care what they do to you, do not give up that arm brace. It's better to give up the arm brace at times or whatever it may be and get that receipt than go to jail or get arrested. I mean, if it comes to that point, and there's so many people speaking right now on the arm brace issue, we've already written a clarification for one of our clients. So I'm going to put together some points, and Gilbert laid it out in perfect format, bullet points. There's 293 pages of garbage and another 35 pages of a lesson plan that's on the internet, and people are interpreting it the way they want to interpret it. And you have to look at it and interpret it for your audience the way ATF interprets it. I interpret it as a garbage, but I have to interpret it and lay out the bullet points so that our clients understand and can do the right thing. And that's a big issue right now. Let's say you just bought or you just sold 100 pistols with 100 pistol braces attached, and your customer has already paid you. And this is real life scenarios that are happening right now. And now I can't ship those guns. What do I do? Because if I ship them, of course, they have 120 days. But in this 293 pages, ATF says we can begin enforcement today if we want to, but we do not intend to enforce till after 60 days, regardless that it's not effective for 120 days. And it's not even hit the Federal Register. So it's going to be 120 days from when it comes out on the Federal Register. So there's a lot of bad information out there, and these people need to really kind of filter it down.
And that's really
we're not
the
going to
trick
prosecute because we're really nice. We're really good guys. So.
And that's really the trick right now. Get it shipped before it hits the Federal Register.
Absolutely.
That's your saving grace right now. It's not on the Federal Register yet. So
in a perfect world, we can dream that somebody in Congress is holding this up, but I think it's just their inefficiency.
So somebody writes in, and I think that he's probably remove this comment if at all possible. My Angry Joe AR-14 pistol has a 6-inch barrel, 25.5-inch with brace fully extended. Let's see. I have another one. This is actually Chief Andre over with the Carco gas station in North Philadelphia. I don't know if you guys remember seeing that story on the news. The armed protectors over in North Philadelphia, because the place had been violently robbed several times. He came on the program. Well, that new law also applied to business owners such as mine, Pennsylvania site agents. It's an NFA item, so this is a federal law we're talking about here. So if you've got one of those, got to make sure that you understand how to comply one way or the other. And you've raised an excellent point, Rick, about folks who are saying, don't do X, Y, or Z, give the middle finger. Well, if you're going to do that and you believe in it to that degree, you must be willing and prepared to go to jail. That's just the practical part of it. You have to be prepared and willing to do so, because, you know, there's a couple of ways to go about it. There's litigating in court the way we do, and Rick is instrumental in so many of these cases when he comes in as an expert witness and sort it out so that nobody is going to jail, or put yourself in that position where you got to say goodbye to your family for a period of time and risk becoming a felon and everything like that. Is it right? No. But if you're going to do that, that's a reality that you have to be prepared to face. And all I got to say is that you get a lot of people who are going to be whining and crying, and their intestinal fortitude is not going to be what it once was when they're talking about not complying. I'm trying to think of a radio-friendly way to say this.
Over in the comments, I noticed Oliver, who was your guest last week, I think, posted up and asked a question about diversified machine. And I think it's a good point that he raises, because when we talk about diversified machine and what they did there, and if you're not familiar, what was happening was diversified machine was selling solvent trap kits, or ostensibly solvent trap kits, which the ATF then decided were not really solvent trap kits. And many of these people had purchased a solvent trap kit and then filed a Form 1 and got approval on the Form 1 and made a suppressor, or what the ATF would call a silencer. And then Diversified started taking heat, and the ATF said, yeah, even though we had previously approved those, we're going to come back and rip them off the registry, because when they left the factory, they were already, in the ATF's interpretation, they were already silencers. And if they were already silencers, they couldn't have been Form 1 because they were already made. They should have been Form 4 after a Form 2 from the manufacturer. And essentially what Oliver's saying is, isn't that a similar scenario here? These things are already made. How can you make something that's already been made? And I agree that is absolutely an inconsistency that the ATF is going to have to grapple with.
And that's one of the things we discussed from the very beginning, is the inconsistency. I pick and choose what I'm going to prosecute and what I'm not going to prosecute. And this regulation, well, they created the disaster. So to try to fix it, in their mind, they wrote a regulation to cover what they created. And so that's their justification. Well, they never wrote a regulation saying that a solvent trap was not a silencer, or they've written numerous letters that said some solvent traps are not silencers. But once again, they pick and choose and decide which one is a solvent trap. It's very subjective, because it's only in their mind what can ever be a solvent trap and what is a silencer.
I think what you're describing is an arbitrary and capricious decision, Rick.
That's
big words.
And I use those words for a particular reason. And the reason I use those words is because the Administrative Procedures Act says that an agency interpretation cannot be arbitrary or capricious. And I think that that's a very, very valid criticism of what the ATF is doing right now.
And I'm going to add a little bit of historical on these solvent traps. The one area when I was with ATF that had been consistent since 1934 was the definition of silencers and what a silencer was. So if I caught anybody, and not me because I'm not an agent, but if you were caught with a pistol or a rifle with a plastic bottle taped to the end of it, you'd have been told that you had a silencer. So you stayed consistent. Then all of a sudden, they said, okay, we're going to say some plastic bottles and some oil filters attached to a muzzle are no longer silencers. Well, how can you do that? Today you prosecute it, tomorrow you don't prosecute it, and now you create confusion to the people who are making these things. So if I can attach an oil filter, which is an extremely good silencer, onto my rifle and use it to catch solvent, why can't I use one of these other devices that I can't shoot through? I have to drill through it to make it have an expansion chamber, but an oil filter has a 5,000 some inch skin, and I can shoot through it with a 22 rifle and then turn it to a silencer in less than a second. So this is how bad this solvent trap decision is.
There's a running theme here, I think, Rick, because it's really similar to what we saw with the bump stock, right?
Well, like we know the bump stock. I mean, I was there when that decision was made, and this thing went all the way up to Feinstein's office before the letter was signed. And so everybody knew what we were doing, and we had discussions all the way up to the director's office, and we knew this was going to be controversial, but we could not call it a machine gun. Well, unfortunately, and we don't even know if the bump stock was used in the Las Vegas shooting. That has never been proved. I'm sure the FBI knows, but that's never been released. And of course, the president made the decision and directed ATF to call it a machine gun when there was a long historical group of letters that said it was not a machine gun.
And that's a whole lot of power when they take this end result and they try to twist and mangle the law when there's no real way that it can fit, right? Anybody who reads the law can't come to the conclusion that a bump stock is a machine gun. Does anybody else disagree with me on that?
Well, one of the problems is we hear things differently than other people. When something, we read things differently than other people because we're looking for the truth. Other people are looking for a way to find words, language that will take something away from you. And that's what happened here. They just came out and changed the determination of what a machine gun was with just a regulation, with not changing the law. So I don't understand how they keep getting away with this, because the law and the regulation are at odds with each other.
Well, that's what I'm saying. Anybody who reads the law can't come to terms with their conclusion. The only way that you get there is if you redefine machine gun in your own head to be any gun that goes bang, 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 bang really fast. That's the way that you get to that conclusion. Am I wrong, Gil?
Or if you're a Sixth Circuit judge.
I suppose so, right? But now we've got a split, so perhaps the Supreme Court of the United States will weigh in on this. And this could be a very similar issue to what we're seeing here with the pistol braces. So maybe we're going to have them reined in a little bit by the Supreme Court. What do you think, Gil?
Yeah, you know what? I would tell this to anybody, like them or hate them, think that bump stocks are ridiculous. I don't care if that's your position on it. The issue here is the way power is being used and the way power is being taken, and where Congress has not, because Congress should be the ones who are defining this. And I would argue that there is some constitutional constraints on what even Congress is able to do. But when we're going to see laws affecting this stuff, it should come from Congress. And right now, it is not. Congress is ignoring this and letting the ATF run back and forth, making up whatever definitions they want.
And there's so many legal issues here, like we mentioned earlier, because it's not just a Second Amendment issue. It's all kinds of powers of government issue. That's really what it comes down to. It's not just something that's limited to firearms, but if agencies can essentially rewrite the law bypassing Congress, that's a major problem. Does that concern you at all as a private citizen, Rick? I know that you've been in this business for a long time and you were on that other end for many years. Does that concern you at all as a citizen?
Oh, well, absolutely. And it was a big concern when I was with ATF. I don't understand the breakdown that has happened. The only thing, especially when it was under Trump, the breakdown started. It didn't start just under this administration. There's been a
Hmm.
breakdown in supporting the public and in doing the right thing by what you're allowed to do. And so they've taken these regulations, they've taken these authorities, and I guess I hate to use this term, but you got like road legislators inside of agencies making decisions that, as you said, Congress should be making, not an agency. If every agency had the authority to regulate what they enforce, they'd all be like the FBI, because the FBI has definitely gone off track, and this is a perfect example of where ATF is heading.
The reason why we've got a legislative process and with all the checks and balances, it's not supposed to be easy. It's not supposed to be something that they could just willy-nilly throw stuff out and impose their will on the citizens and the people of the United States. Our founding fathers understood this. And maybe we don't need a billion trillion laws on the books, but that's what we get with these agencies, because they don't have to go through that process. They don't have to get approval. They don't have people who are accountable to their constituents. That's another very important thing. Chris, as a private citizen watching this, as somebody who's a gun owner and somebody who believes in our Constitution, what do you think about when you hear this conversation talking about this stuff with Rick and Gilbert?
Yeah, it's fascinating. And, I'm being a little quiet here just because you guys are obviously the subject matter experts on the topic, and I'm kind of taking it all in. But, it's just very frustrating for me to see this process once again, where they're, reaching, into our personal lives. And I'd still love to understand how they feel any of this makes these items more dangerous than any other firearm in any given circumstance. Like, it's basically ridiculous, right?
Well, and I can actually answer that in part, because
please go
read the rule. If you read the rule, they cite to two instances, one in Dayton, Ohio, and one in Colorado, where a braced weapon was used in the commission of a mass shooting, a violent crime.
I see.
And so essentially what they're doing is they're taking these two examples, and they're saying, based on these two examples, we think that these weapons combine the power of a rifle with the concealability of a handgun,
right?
And we're therefore going to come after them. We're going to come after these braces.
I mean, based on that, I guess then I think we should probably ban all firearms.
but that's about all firearms are dangerous. You're exactly right.
Exactly.
So we got a local delegate here in Virginia, out of the Spotsylvania area, who posted something recently, and I'm going to butcher the quote because I don't have it in front of me, but essentially what he was saying was, if your rights depend on criminals not misusing those rights, eventually all of your rights will disappear.
Yeah,
and I could not agree with him more, because if what we have as gun owners is dependent on them never being misused, you can't have two instances where people misuse them.
Yeah.
Then you might as well consider all of your rights gone.
Yeah. Well, as we all know, it's one of the few things where they blame the item and not the individual. I mean, we should ban cars, we should ban knives, everything else. So
right. Well, when you come up with a couple of examples like that, it's very clearly correlation doesn't equal causation. It's like saying they're both wearing green hats, so we got to get those off the shelves too. Rick, because you're the business end expert, right? You deal with the business end of firearms. How would you try to explain to somebody how these things are so much more dangerous than everything else?
Well, I couldn't. There's no way to explain that they are more dangerous. I'm also a firearms instructor, and I've trained numerous people at every different level on how to use firearms, from basic housewives to tier 1 individuals. And a firearm is a tool, and we in the community treat it as a tool. The problem is it's also a tool to the criminal. And for him, it's an assault device. To us, it's a defensive device, because I don't take my gun and go into a 7-Eleven and attack in an assaultive manner to take their money. I may carry my firearm in my holster concealed to use it in a defensive manner in case somebody attacks me or my family. And the criminal is completely opposite. But when you look at the rhetoric, it makes it look like all of the law-abiding people, especially crazy and arm braces, have bought these arm braces just to assault the safety of all the innocent people out there. And that is one of the biggest issues, that they look at everything in reverse, because they can punish us because we were raised with morality and a sense of law, and the criminal does not have that morality or sense of law, and they cannot be punished because they'll go to jail and they won't be fearful, and they'll come out and do the same thing as soon as they come out.
Well, and that's the other farcical thing here, is they're not even banning them, really. You know, it's not like these things are so terrible and we need to get them all off the streets and round them up immediately. They're saying, yeah, as long as we have your fingerprints on file, they're okay.
Yeah. Yeah, that's true. It's true.
Do you guys have any thoughts on what they'll try to come after next?
Binary triggers.
Okay. Yeah.
All the states are pursuing magazines and ammunition, to try to do that federally. I don't know what they'll do.
Yeah, and there was a part of the rule where they addressed negative comment from somebody that by doing this, they're effectively banning them in certain states because of the way the state laws are written. I've had a couple of questions about New Jersey on this come up, and they kind of brushed that off to the side.
Yeah, that's a state problem, right?
Yeah, right. Yeah, that's pretty much what I got when I read their response. Like, that sounds like a you problem.
They do a lot of the rule, I think, is written to demonstrate process, to show that there's due process, right? They here's what you can do. You can register, you can do this, right? We're giving you some process here. We did this only after comment and after notice and all of this. But there's kind of an interesting issue, because if you are in a state like New Jersey, what process is there for you?
Right.
Well, I don't even want to respond to that, because in New Jersey, I'd be terrified to own a pellet rifle.
Right.
And I actually just saw Rick
Slingshot's a felony. Slingshot's a felony in New Jersey, Rick.
Yeah, you gotta love New Jersey. Yeah.
And go charge. I'm going to have to leave you guys here in the next couple of minutes, unfortunately. But
okay. Well, we've got 8 minutes left in the seven something minutes left in the show. So
it won't be the same.
We'll have to make do without you, Gil.
8 minutes, I can probably squeeze that in.
Okay. Yeah. 8
Hey,
minutes
now to everybody in the comments too. Hey now.
Yeah,
Got
we
some
got a
people up
comment from
north
Eric
tuning
over
in
here.
too, Michael Clay.
It says rules are written by non-Congress entities, and it takes years to come up in courts. By then, it is common law. That is an interesting point, right? Because you have the people, like Rick said, who hear about this, they comply, they follow the law, and it's really sort of a chilling sort of effect on people with other things as well, because they don't want to end up in this situation again. So maybe people are going to be more hesitant to even wade into the territories of certain things that ATF has said, yes, this is perfectly fine, you're good to go. And now they just don't trust it anymore. Do you think that's possible, Rick?
I've heard a lot of rhetoric Nacho, where people are very hesitant of filling out a Form 1 because they're looking at it as ATF just trying to start a registry and knowing exactly who has one, and then continue to follow what type of firearms that you have. And 5 years ago, I would say that, you're just, out there with the tinfoil guys. But today, I don't know, is that really what, because let's say this goes to court and ATF loses, and then they get some Congress people to decide to change the law. Let's say that actually happens. So now they have a registry of all these people who have arm braces, and the law's been changed, and they can come directly for you. Now, like I said, I'm thinking like a tinfoil hat guy now, but there is that possibility.
I don't think it's so tinfoil hat to say that if they're saying that something is and always has been illegal, punishable by up to 10 years in prison, but they're giving you word that they're not going to do that, even though they just reverse, by way of this rule, they are reversing course on something that they gave you that same word on, right? How good is their word if there's
So there is some rational thought to that, to be fearful of, what did Ronald Reagan say? The most dangerous words or scary words you ever heard is, "I'm with the government. I'm here to help you."
No,
That's right.
That's right.
That's right.
Help.
Gil, any thoughts on that?
Oh, I totally agree. I mean, I don't know. I get funny looks, I guess, with my tinfoil hat in public, but I don't think
I was going to
you're
say I'm
wrong
kind of
start-
happy to be included in that group these days.
Yeah, I don't know that you're wrong to start wearing it, because
Yeah.
it is. I think very much this has a deterrent effect on innovation within the firearms community. What good is innovation if you can send off to the ATF, get an approval letter, start a business up, figure out your manufacturing, supply chain issues, marketing, advertising, connect with customers, come to things like SHOT Show and pay the fees for a booth and advertise it, and then the ATF's going to turn around and say, actually, although we said you're good, you're not actually good, right? So it's going to have a hugely detrimental effect on innovation and people's willingness to experiment. I mean, the fact that you have to worry about what the ATF is going to say in the first place is scary, let alone not being able to count on what the ATF says.
Defyland in the comments says that's racist. Maybe it is. Everything else is these days.
It's entirely possible. Maybe that's the one. Maybe that's the legal argument.
Yeah.
So Rick, moving forward, people are probably wondering, how do we combat this? How do we do something about this? Do you have any advice to people?
Well, there are going to be lawsuits, without a doubt. And I met with the people from SB Tactical and their attorney already. And of course, these guys have deep pockets. They've made a lot of money, but a lot of people have made a lot of money off of them. So I think when time comes that people should chip in, and people should definitely be heard, and make sure that their Congress people and everybody else hears, inundate them with letters, inundate ATF with letters to tell them. But when this thing first came out, I asked people in online, when you respond professionally, and respond with, don't say this is Mickey Mouse and I don't give an F, and or something like that, and you're all Satans and stuff like that. Lay out your thoughts as good as you can and tell them why what happened is incorrect. And we've got to get a movement started. The left does an extremely good job of moving their legislators on their favor. We have to do the same thing.
I know somebody who, in their reasoning for the Form 1, said, "Tread on me harder, Daddy," was the reason. That's the reason
Turn that
listed.
into a shirt or something.
Here's what happened. Those letters don't even get looked at. They go in the trash, and all it does is just waste the real good comments time, because so they're not going to have time to read the 150 good comments, because they're just having to separate the 500,000 bad comments. So write in a professional letter and support all the litigation that happens.
This was on the Form 1 itself. I want to be clear about that. It was not on a comment. Gilbert, what's your advice for people who want to move forward and get involved?
Yeah, well, first thing I would not do is I would not immediately, they're saying you've got 100, assuming you're an individual, not an FFL, they're saying you've got a 120-day grace period to get an application in. I mean, certainly if you wait, the wait times are going to keep going up as they get inundated with Form 1 requests, but I would still wait. And the reason I would wait is because I would give this thing a little bit of time to play out, because there are going to be people asking to join this. And I would absolutely, as Rick says, support those efforts, because this litigation takes an incredible amount of effort. It is expensive. Got to hire experts like Rick Vasquez to come in and talk about what's going on with the braces. And that all takes money. And so help the groups that are going into court and challenging this, and, sort of watch how this all plays out. Don't rush to do something that you might regret, because this might get enjoined. There might be other creative ways that people figure out to deal with this. And if you happen to be the first one who, ripped off your brace and destroyed it before they even published it in the Federal Register, you're going to be out the brace.
That's very true. Wise words, gentlemen. It's been an absolute pleasure having you on the program today. We got Rick Vasquez, rickvasquezfirearms.com. Check him out. And my esteemed colleague, Gilbert Ambler, amblerlawoffices.com. That's all the time we've got for today. Stick around for We the People, the Constitution Matters. Pastor David Whitney, Professor Philadelphia. I'll be joining as your legal analyst. We missed you, Ellie. Daddy loves you. Thanks for joining, gentlemen.
Great.
Thank
to see
you.
guys.
Peace and love, everybody.